You know, it's not a legal requirement to write a will, but it should be, especially if you're living with someone but not married, or whether you're married or in a civil partnership, and you should definitely have a will if you have children. If you are among the 60% of people that don't think it's important to have a will, just listen to this short video and I'm sure you'll think again and realise how vulnerable you are without one. There's no substitute for an up-to-date will, and believe me, if you've ever seen the stress, cost and wasted time of those left behind when someone passes away who hasn't written a will, I'm sure you'd get yours done straight away. Is it because you don't think you've got enough time? Because that's really not true. Seriously, it just takes literally a couple of hours of your time and that's it. And I doubt any of us have a problem finding a couple of hours in our busy lives for something this important. So what other problems might you be facing? Perhaps the thought of your own mortality is an issue. Maybe you think all your worldly goods will go to the right people anyway, and how wrong could you be? Maybe you don't think you have enough to justify writing a will, or maybe you feel you're too young. Whatever the reasons, not having a will makes no sense to anyone of any age, and here's the legacy you'll leave behind if you die intestate, and that means dying without having made a will. So what is the legacy you're likely to leave behind? Let me tell you what can happen if you don't write a will, and what people will think of you for not having done so. It's a common misconception that if a couple live together, they will gain rights by being, in quotes, a common law wife or a common law husband. But there's no basis in English law for this. There's no such thing as a common law wife or husband, regardless how long you've been living together. Things get even more complicated if you own property together, and worse still if the property belongs to only one party in that relationship. But if you're married, there's still a misconception that your spouse will inherit everything, and that's just simply not the case. They will get a maximum of £250,000 and half of everything else. Let's face it, what is £250,000 going to buy you in the current day and age of property prices? So the children get the other half of what's left after your spouse has had their £250,000. Interesting. So what would happen then if the children decided they wanted their share there and then? Well, it may mean having to consider selling the family home in order for them to have what is legally theirs. Believe me, it's an absolute nightmare to try and untangle the affairs of someone who has died without making a will. Not least of which are people who will be fighting over things they think they were promised. Then you have to track down the beneficiaries. These are the people who are entitled to benefit from the estate. If someone has died without a will, you have to track down the relatives of the deceased. You have to make sure you've not overlooked anyone who's entitled to benefit. These days, people could live anywhere in the world, and you have to locate them, correspond with them, and possibly even in a foreign language. Nothing is straightforward. It's a really difficult process and 10 times more time consuming than when a will has been made. Social services have a duty of care in these situations and will immediately place vulnerable children with people who can take care of them. This could easily mean a family of children may have to be separated, and this would add even more stress to them. Bearing in mind they are already in a confusing situation, they don't understand what's going on, and separating them will make everything even worse. Can you imagine how you would have felt if your parents had suddenly died and you were placed with a family and separated from your brothers and sisters? Just as important though, they could be placed with people who have completely different values to yours. In a will, you can name the people you want to be guardians of your children. You have that choice, not social services. In a will, There are plenty of opportunities to minimise inheritance tax. You can use things called trusts, and you can start to look at ways in which you can give away your assets in your lifetime. And then your estate, this is all your worldly goods, is of a lesser value and you will pay less inheritance tax. At the moment, inheritance tax is a whopping 40%. That's 40% above any allowance you are entitled to. That can soon eat away a massive part of what you own, leaving far less behind to leave to your friends and family. Now, without a will, your estate is distributed according to the law, and you have no choice as to what happens. So if you have friends you'd like to leave a gift to, or even a sum of money for example, you can't do that, because the laws of intestacy, the laws which kick in automatically if you don't have a will apply. If you want to look after people you really care about that are outside your family and their relatives, or if you want to make donations to a charity that is dear to your heart, then it's too late. Without a will, this simply will not happen. It's also possible, in worst case scenario, for everything you own to go to the state. So, who will benefit if you haven't written your will? Well, firstly, it will go to the children of the deceased, and then on down the family tree to parents, brothers, grandparents of the deceased. But if no immediate family are alive, then it will pass to half-brothers, sisters, aunts and uncles. And that may not seem too bad on the surface of it, but what if you are estranged from one of them? There's no way you can stop them inheriting if you haven't written a will, and if none of the people are alive at all, then it all will go to the state. The amount of money going to the Treasury from the estates of people who've died intestate is rising year on year, and although the figures are not available for 2019, it's likely to be over £40 million. So I don't apologise if you feel I'm being too much in your face with this video, but I need to do something to kick-start you into taking writing your will more seriously. I say this all the time. It's never too early to write your will, but it certainly can be too late. The truth of the matter is that none of us know when our time is up, but when it is, there's certainly no way of writing your will from the grave. If you've listened to this entire video, I hope you found it useful, and I'd like to give a gift to you. I'd like to offer you a free, no obligation consultation on what you should be considering when writing your will and what is important to you. Please phone me now on 07958 221460. So if you now think it's time to get your will written, perhaps consider powers of attorney, which I'll cover in another video, then please contact me at City and Country Financial Services. You can email me at roger.borden@ccfs.london, or you can contact me directly on my mobile on 07958 221460.